Yeah, no. I want that bill. I want your bill out there.
Sarah, good. Sarah. We are live. There's Sarah. Nice to see you, Sarah.
That's not Sarah. Oh, yes, Sarah. I'm sorry.
It is Sarah.
I thought you said Sarah Goodenough.
Who did you think it was?
I was looking at Goodenough. Not that Sarah Rouse is not good enough. That's not what I'm saying. All right, let's move on.
Be careful, sir.
Let's move on.
That is on the record, Senator Norris.
Let's move on. Yes, I think that's a good idea. Sarah, good morning. We're talking about different bail bills. There's a slew of them here. So, but we wanted to hear from you on bail issues, and we've been more generalized than the specific bills.
Well, thank you so much for having me. And I appreciate all the conversation. I haven't been able to listen to everything that you've been discussing this morning, kind of popping in from another meeting, but I came prepared to talk most specifically about S-196, but also happy to field any questions that you may have about the broader conversations you've been having. So thank you again for the invitation to speak. And in terms of S-196, I know that you've received testimony from the Department for State's Attorneys and the Defender General and others. So the proposal, as I understand it, would allow a victim's sworn or recorded statements about the history of abuse and threats to be used in lieu of their physical appearance and testimony at weight of the evidence or bail hearings. And there are a few reasons why we believe this proposal will be beneficial to victims of domestic and sexual violence. First, these hearings are most common in serious felony domestic violence cases, those with the highest risk of further violence and abuse. And we know that the period of time directly following separation, which sometimes is a separation by choice and sometimes it's a separation that's precipitated by an arrest between abusive partners and victims, is the most dangerous time for victims, and the research really bears that out. In addition, requiring victims to be physically present at such a hearing directly following a serious assault compounds the trauma that's experienced by victims. I want to talk just big picture about pretrial detention and say that as an organization, the Vermont Network understands the really significant impacts that holding an individual pretrial has, not only on their rights in terms of their freedom of movement and liberty, but also on that person's family, their employment status, and other considerations. And broadly, as a matter of policy, the network would like to see better and more robust community-based pretrial monitoring systems in cases of domestic violence. Currently, our state really has very minimal tools to help ensure victim safety pretrial in all domestic violence cases, from misdemeanors to felonies. Many other states use other tools such as integrated domestic violence courts, judicial or corrections pretrial monitoring and supervision to help ensure community and victim safety in the pretrial stage. But without the existence of such a robust or effective pretrial monitoring system, we do believe that pretrial detention is an important tool of the justice system, especially in dangerous felony domestic violence cases. This period of time is essential for protecting the physical safety of victims, but it can also reduce the likelihood of abusive partners further coercing partners in that pretrial stage right after separation, and can really provide needed time for safety planning for victims. Sometimes that includes establishing new housing, attending to medical, financial, or legal needs that are all part of the safety planning that victims of domestic violence often need to attend to in the wake of serious abuse. So on the merits of S-196, the network supports the proposal. We thank the committee for your consideration of it, and I'd be happy to talk to you more broadly if you have particular questions about bail or pretrial detention that I might be able to answer for you.
Senator Hashim.
Hi, Sarah. It's good to see you and thank you for testifying today. I was wondering if you could spend just a little bit more time talking about the accuracy and reliability of testimony when it comes, or when it has to happen within 1 to 2 weeks of an assault versus months down the road.
Absolutely. So we know much more about two things. We know much more about the neurobiology of trauma and how people integrate experiences they have. And we know that sometimes statements are maybe a bit incomplete if they are gathered directly in the wake of violence, like within a few hours or even the next day, but that often after even just a few days, that those statements are likely to be the most accurate as there's proximity to an event. And honestly, the brain has had the opportunity to re-regulate. Often sleep is a part of that process for many victims. It's the exact same reason that when there are officer-involved shootings in Vermont, the debriefing of officers involved, I believe, happens not often directly immediately, but in the days after such a critical incident. But the further a victim gets from a particular experience, especially when, in the case of domestic violence, that kind of violence often happens as part of a course of conduct that is much more long and robust, but our justice system is often focused on a singular incident. And so it is our belief that sworn statements from or recordings of victims in those moments that are more proximate to those incidents are going to be likely more useful to the justice system.
Thanks. And one more follow-up. Do you have thoughts on situations in which a victim has been either scared to testify or has just flat out refused to testify in person in front of their abuser, and what have the results been when that's happened, or if that's happened?
I would say that happens quite frequently. And there are many reasons why victims may choose to engage or not engage in the legal process. And as you all know, essentially once law enforcement has been called, they determine that they write an affidavit of probable cause and something has been charged. Victims don't have a whole lot of agency in terms of what happens in the process then. It's really, again, these cases are the state versus an individual. The state is making those determinations. And so sometimes for victims, the only agency they have is the agency about choice of participation. And so one of the things that we are always in support of is making that participation, ensuring that victims have as much choice as possible in terms of how they might participate, and ensuring that it is as trauma-informed as possible. One of the ways that we can do that is provide victims with opportunities to participate in the process, to be useful as state's attorneys are moving cases forward, but to also limit the risks of safety that victims may have, and that's both their physical safety and their emotional safety. And so the opportunity for victims to not need to be present in the courtroom with the person that assaulted or abused them is one way that we can ensure that our process is more trauma-informed, and I think will increase the likelihood that victims would be willing to participate in such a process.
Thank you.
Thank you. Senator Bohowski.
Hi, Sarah, thanks for being here. You may not know the answer to this question. It may be more of a question for the courts, but is Vermont a place where a victim could be subpoenaed to be in court on a case like this and then charged with a crime if they don't come?
Subpoenaed for what purpose, I think is the question.
So I guess
At what point in the
question would
process?
be like, so I have had a personal experience in New Hampshire where I didn't want to participate in a case like this, and ultimately the court served me with a subpoena and said, if you don't show up, we'll arrest you. And so I guess I'm wondering if that type of practice is happening in Vermont as well.
It would probably be a great question for you to ask the state's attorneys. I would say, by and large, my sense is that state's attorneys seek to provide as much information as they can to victims, seek to support them in their participation in these cases. But often, if a victim is unwilling to participate, what the real result of that is that the case will simply not move forward. And so I think that that's the more likely outcome to occur in these cases.
That's helpful. And I think really what I was trying to get at is how much choice to participate does a victim really have? Because when the court steps in and says you have to participate or we'll arrest you, there's, I mean, yeah, I guess there's a choice, but it's not, yeah.
Yeah, and yeah, certainly, you know, we wouldn't be supportive of that kind of practice. And my sense is that just very broadly, that state's attorneys are generally not utilizing those types of tactics.
Wonderful, thank you.
Okay, any other questions for Sarah? Thanks, Sarah. Appreciate it.
Thank you so much. Have a great morning.
The next, oh, do you have a question?
I do have a
Sarah?
quick question. I don't know if it's for Notter or alleged counsel. In reference to the bill, which I had here in front of me, what's the difference between what you're I support the bill. What's the difference between what you're proposing in 7553A right now? Well, what are we looking for here?
What difference compared to what?
7553, which is the bail and
So-
recognizes.
So for all pre-trial hearings, except for motions to suppress, the rules of evidence don't apply, except there are some judges who have different interpretations of Supreme Court cases and are applying the rules of evidence, specifically for 7553A hearings, which will then require what Sarah was describing, the victim coming in 15 days after within 15 days of arraignment to testify that they were assaulted or whatever the facts were. That victim will still be required to testify at the trial because of the Sixth Amendment. But for pre-trial, generally, the rules of evidence don't apply. And so this is kind of clarifying that. So for example, for 7553 hearings, the rules of evidence don't apply there. And those are for life imprisonment cases. Whereas for 7553A, some judges are interpreting it that the rules of evidence do apply, whereas other judges are not doing that. So that's the clarification that I'm trying to make.
Okay, all right. I'm still a little confused on it, but I know what you're heading for here. Yes, thank you.
Senator.
I have a follow-up for Senator Hashim. So this really isn't a change of law. It's a clarification of policy and lining up what everyone's doing to be the same.
That's the way I see it. Yeah.
Okay. Thank you. Have we heard from the Defender General on this?
I have no idea.
Yes, they did not like it.
Okay. I mean, I assumed that that would be.
I think you were
I might have been absent.
Yeah, dentist.
Yeah, I think I might have been. Late. So we have, is Tucker Jones on YouTube?
He's on Zoom.
YouTube, I'm sorry.
Well, he'll also be on YouTube.
It could be, yeah, it could be on YouTube, I guess.
I'm here, Senator.
Good to see you. All right. Any comments on bail? I don't know if you heard earlier conversations with the Justice Center about bail. Any comments on bail or specifically on 196?
Yeah, I do. If it's all right with you, Senator, I'd like to return to that conversation from before the break. I don't have any specific comments on 196. That's really a topic. It's more for the state's attorneys than for me. And I know my name's listed under 196, but I did have some comments prepared to return to that conversation on the revolving door issue on pretrial release.
Yep,
So what I was hoping to do is to speak a little bit about the legal mechanisms for the consequences when there's a failure to abide by the conditions and you have the repeat criminal behavior while on pretrial release. You know, this is a topic I've spoken about, I think, every time so far when we've met about engaging in criminal behavior in this period of the criminal justice system before adjudication. And what I would characterize as the limited tools that are currently available to address this scenario and the harm to victims and communities that can result. Your conversation in part has turned this morning on the scope of supervision or lack thereof during this phase. I want to speak more towards the available legal tools or lack thereof during this phase. The tools are limited to some degree, as I've mentioned, in Vermont, because of the unique Vermont constitutional standards for withholding, imposing, and revoking bail. Those three standards. There was some discussion of them a few weeks ago with Ben Novogrosky giving the overview of the landscape for bail. But it's really in light of those three standards that I've put together what I'd characterize as a menu of potential legal mechanisms to address this issue. And I sent that to Ben, Legislative Assistant Ben, to post. And if he can, I wasn't sure if he was able to print it out for you as well. But
don't think I should print out under what bill?
That's 196.
On 196?
it's
Hey, give us a moment to find the printout. I don't have it under 196. I don't have it under 387. I have it now. Thank you. Does everybody have this?
Is it online, Ben, or?
Yeah, it should be online as well, yes.
Okay,
Oh, I got that.
Might be-
we've got your legal mechanisms related to trial
And
revolving.
I really appreciate it. Thank you for cutting it off. And I'm sorry I'm not there in person to have brought my own copies this morning. But this is just a one-page document with 6 bullet points. And I just want to run through the bullet points for you. In the online version, I added the links to the relevant bills and acts and cases that you can, just click on when you have it online, but you also have the printed out version as well. So I'll just run through all 6 relatively briefly. The first is the topic of imposing bail. So, of course, Ben Novogrosky went over the purpose of imposing bail in his original talk. I'm not going to get into that now. But as you know, in Act 164 from 2008, which is linked there, it puts a $200 cap on bail for expungible misdemeanors, among other changes from 2018. I want to flag for you that H775 is a bill that in part just repeals Act 164 from 2018. So it takes all those changes and repeals it. This is the administration's proposal to repeal Act 164 from 2018. And it just essentially takes all of those changes there and reverts them back to how they were before this time. I also want to flag that there's a proposal in S287 to revise the $200 cap. And the revision is by striking that limit for a defendant who has been released pending trial for another offense. So it's specific to a modification of the $200 limit on bail for someone who's on pretrial release already and is charged with a second crime that would be an expungible misdemeanor under the current scheme, but it would lift the $200 cap there. And I know that on the schedule, Ben's going to do the walkthrough of S287 maybe in a bit this morning, so I'm not going to go into a whole lot more detail on that at this time. But S287 also calls for adding whether someone is under release in another case to the factors the court considers in imposing conditions to protect the public. S-195, which was up this morning, also attempts to do this, but the location of the language change is different in S-287. I'd recommend just comparing the S-287 location to the S-195 location. I think the S-287 location for the addition of these factors is a little better. And the S-287 language is a bit more thorough in the scope of behavior, the pretrial repeat criminal behavior to cover. So I just wanted to flag that. S-287 also revises the definition of flight from prosecution to expressly include noncompliance with court orders and failures to appear at court hearings. This is a modification of Act 164 from 2018, which added that statutory definition of flight from prosecution. It contemplates the concept that persons who fail to comply with court orders or don't appear at scheduled hearings are more likely to flee from prosecution while on pretrial release. So there's more in S-287, of course, some of which I'll mention in these other bullet points. But also I obviously want to, I want to flag that the state's attorneys will have more to say on S-287 as well. So I hope you have them in on this topic next week, which I think you are, Senator Sears.
Yeah.
The second point is flash cites, also known as flash citations. That's a citation for a criminal offense to appear at court the next business day for an arraignment. You may want to consider whether you want to give some legislative direction that some violations of conditions of release, especially when the violation constitutes a new crime, are important enough that they should be quickly arraigned. The legislature does this in some other areas like domestic assault. I just give you that reference here that a person cited for domestic assault shall be arraigned on the next business day after the citation is issued. That's a flash cite, except for good cause shown. Just flagging that there is this phenomenon where an individual will be on pretrial release for a serious offense, engage in criminal conduct, but the citation will be, 8, 10, 12 weeks out, and it's clear that it's insufficient to address the severity of the behavior that the court's seen. So you may just want to explore that. The third point is a proposed enforcement scheme for violations of conditions of release in S-287. It begins on page 10. There's a whole scheme there. Again, if Ben is going to be doing a walkthrough, I'm not going to go into detail on this, and the state's attorneys will also have input on this scheme when they address 287 later on. But this is about adding tools to the toolbox for enforcing VCRs in a faster way than waiting to the eventual adjudication of all the underlying offenses. That's the thought here. One flag on this topic in S-287, it currently calls for the repeal of the existing VCR scheme. I would not recommend doing that. I would keep the existing, I believe it's 7559 VCR scheme in place, but also give real serious attention to this issue of the length of time it takes to resolve the violations of conditions of release and what other mechanisms are available to intervene faster when you have these violations. So I'm just going to keep going, Senator Sears, since we're on it. Is that all right?
Yep.
The fourth point, pretrial risk assessments and need screenings. I'd highly recommend taking a look at that statute. It's 7554C, little c. In Title 13, orders under that statute in subsection D, they're unenforceable by the express language in that statute. It's subsection D4. So we would recommend striking this provision and making those orders enforceable orders. These orders,
Can we require a defendant to do that? That's the question. They've not been convicted of a crime. I believe that's why we had that language in the first place. Because it is essentially voluntary. There could be consequences for not doing it, I suppose, and I think it's to everybody's advantage to have the screening, but I think we made it voluntary because I don't think you can require somebody to do something who hasn't been convicted.
and that's obviously going to be, folks will have more input on that topic, of the degree to which you can require people to do something. But of course, that's what conditions of release are. Conditions of release pre-trial, you require people to do all sorts of things, and to refrain from doing things. And there is a difference there of in order to refrain from engaging in certain conduct versus in order to affirmatively, engage in certain conduct. These orders here are essentially telling a pretrial defendant that they have to engage in particular conduct. But I'm just flagging it for you that, 7554C is a potentially, could be a more important statute than it currently is if you have some mechanism to really.
I've long felt we should have pretrial screening. We should know who we're dealing with. We should know what the problems are and try to address them as soon as possible.
And so you're aware under 7554C, right? The orders include orders to meet with a pretrial services coordinator, to participate in a needs screening, participate in a clinical assessment for substance abuse and mental health treatment, and follow the recommendations, and orders to otherwise engage in pre-trial services. So
that out of the 2021 Justice Reinvestment 2 was partly the genesis of trying to get screening done and shared in the community, but I was more on the other end. But I don't disagree with the need for that. Anyway, please go right ahead.
yeah, so the thought is to definitely just give that some focus and some more attention of how that process is currently working. And again, I can't speak to that operationally, but I just, think it would be helpful to understand how that process is currently working and ways to improve it. And one of them potentially that we'd recommend is to, consider actually making those orders enforceable orders. The fifth is civil contempt. And so this is along the same lines, actually, of the enforceability of pretrial orders to engage in certain conduct. Civil contempt, it's a common law tool. It's codified in Title 12 for general application. The legislature has codified this power for particular purposes, like failure to pay child support. So like under Title 15, a court can impose coercive orders, including detention, until someone purges themselves from contempt and complies with a court order to perform a specific act. So one of the recommendations here is to codify civil contempt for pretrial orders to perform certain acts, including potentially, and what we'd recommend, orders under 7554C. The bill language for this has been drafted. It's based on civil contempt in Title 15. And I just flagged here, and it may be of more interest to Ben Novogrosky, but all of you, I'd recommend getting a sense of the civil contempt overview. And there's a case here that kind of goes into the landscape for civil contempt. And then the sixth topic is revoking bail. And I think in one sense, the reason we're having this conversation, the reason we're having this issue of not having an effective means to intervene pre-trial when there is a series of repeat serious criminal behavior is because the limitations on revoking bail in Vermont are very stringent. There's a high constitutional standard for revoking bail, and that some other jurisdictions, including the federal courts don't have this high standard. So I'm flagging it here for more focus and consideration on this topic for your committee, because it really is, in one sense, at the heart of the issues that you were discussing earlier this morning of when is it too much? You know, how many pretrial offenses are really just too much? There's the federal statute I referenced here is 18 USC 3148. I think it's really worth comparing that statute with our federal or our state revocation statute, which is in 7575. But don't take 7575 just on its face. There's a constitutional overlay to 7575, and it's explained in part in State v. Suave on the constitutional limitations on revoking bail in Vermont. The bottom line on this scheme of revocation is that repeat violations of conditions of release themselves cannot result in pretrial detention as a Vermont constitutional matter unless those violations really impede the prosecution of the defendant, as understood and discussed in State v. Suave. And it's really quite a high bar that is set in State v. Suave. They talk about threatening the integrity of the judicial system, and the conduct really has to rise to that level. So I'd recommend reviewing 7575 and Suave and consider as one option to statutorily define impeding the prosecution consistent with Suave. Now, I say this knowing, of course, that the Constitution trumps statute, but it is one area of law that has essentially not seen much substantive legislative attention for 30 years. The legislature has not hesitated to weigh in on its view of the definition of constitutional terms in other areas of bail law. And that's why I suggest that it's actually potentially fruitful for your committee to examine this area of bail law as well, revocation of bail, which is its own constitutional standard, separate from the standards for withholding bail, separate from the standards for imposing bail. And so I mentioned that the legislature has weighed in elsewhere on bail law, right? One example of this is that in 2011, a single justice decision ruled that lewd and lascivious conduct with a child, in that case, did not constitute an act of violence for purposes of withholding bail under the Constitution, under the Vermont Constitution. And the legislature did not sit back there. They responded in 2015 by passing a provision for that offense that just states conduct constituting the offense of lewd and lascivious conduct with a child under this section shall be considered a violent act for the purposes of determining bail. In 2015, Act 43. The legislature never weighed in a similar way after Suave on the revocation standard. So I just consider thinking about that, exploring the topic, consider weighing in a manner that's consistent with what the court has described.
I'm wondering, are you talking specifically about repeatedly violating conditions of release and the requirement that it impede the prosecution of the accused?
Yes.
I mean, that's where the problem lies.
Yes. And, the court has described what it means by impeding the prosecution. It's a constitutional, standard that they have described to narrow mere violations of conditions of release. But there's some sense of honing what policymakers, what elected officials believe impeding the prosecution really means and threatening the integrity of the judicial system really means. And there's opportunity for dialogue there that I'm not aware of having occurred.
Well, this goes back as long as I've been here. In 1992, the there was a constitutional amendment on bail that I'm sure you're familiar with. And then in 1993, I was elected in 92, that same year, and started serving in 1993 and was on this committee. And there was quite a discussion about how even in 1993, the Supreme Court was not interpreting the bail statute in the way that the legislature intended when they approved the constitutional amendment. I don't remember which number it was. But at that point, I can remember John Bloomer Sr., who was chair of this committee, and Vince Aluzzi going over to the Supreme Court and arguing about what that bail constitutional amendment had meant. And I believe that the argument was basically that public safety should be a consideration in any bail determination. So it goes back 32 years, this argument about how bail should be interpreted.
That's right.
That's a little historical background, and obviously there's a few things I've forgotten about that conversation, but that was one of the first actions Senate Judiciary took that year, was trying to make sure that it's clear that public safety was a priority in that statute, or in that constitutional amendment. It goes back that far for me. And that's enough of a history lesson.
Senator, I appreciate the history lesson. Those are the 6 areas I'd flag for the revolving door topic and what can be done this session about it. Happy to discuss it further. Happy to take any questions if the committee has any.
Any other questions? I think what we're going to do formally is settle on one bill and then put parts of all of this together into one omnibus bail bill. And some of it the administration may like, some of it they may not like, but we're going to try to get my goal is the violations of conditions and the lack of supervision and training. We talked some about, this won't exactly be public safety, but having some supervision for people that are out on bail who have conditions of release, to make sure that they follow the conditions. We have the esteemed minority leader, Senator Brock from Franklin County, the other. Was he the junior senator from Franklin?
No.
I don't want to get confused there.
Hats off, he's a senior senator.
So Senator Brock is going to talk a little bit about why he and Senator Norris and Collmore are introducing S-287. So please join us. You have Mr. Tucker Jones, who's on YouTube, on Zoom, joining us. He's the lawyer for the Department of Public Safety. And Lieutenant Daniels is here as well from the Department of Public Safety.
And I understand that Ledge Counsel, Ben, is going to actually be doing all the talking about the important stuff today.
Yeah.
I just want to be very, very brief. The governor touched on it yesterday in his budget address, and obviously many of us have talked about it previously. In many communities, in many areas of Vermont, people are simply concerned about public safety and what in some cases has been thought to be a deterioration in the safety that all of us who live in Vermont have come to expect. One of the things that I hear a lot about, I hear from constituents, is the concept of what many call catch and release. You know, there's people
We're calling it a revolving door in here, but it's
the same thing.
Catch and release is fine.
But that is one of the concerns. And I thought just to illustrate it, here's a copy of the letter. And of course, the printers that we have here are designed to print in print that only can be read by ants. And so if I make a mistake in reading this, it's because the print is so tiny. I have a pair of superb reading glasses, if I can find, that may make it a little bit larger. But it is illustrative of the kinds of issues that so many people are seeing and so many people are talking with me about. And this is very brief. And actually, I got sent this by a superintendent of schools in Enosburg who received it directly from the constituent. And essentially, it says blank blank, which is a name, is the thief who keeps stealing vehicles in Enosburg. VSP has been notified each time and continue not to do their job. And blank blank has violated his parole conditions countless times since he was charged with attempted murder as a hate crime in 2021. He continues to sell drugs, steal cars, cause local businesses thousands of dollars of damage, definitely rob blank store in a red hat, and that makes the community a terrifying place to live. The police had witnesses tell them he saw them do these things, stolen vehicles, and have not done anything. So-and-so has confessed to being an informant for the police, and that is why they continue to let him go. He's a danger to everyone. Please share this with the Vermont State Police, and maybe then they will see that members of the community are fed up and ready for action. This is not the only letter that I've gotten about this individual and about this set of circumstances that are happening in Enosburg. I've heard similar things in Richford. I've had similar conversations in St. Albans. And of course, all of us have certainly read in things like Digger and elsewhere about perception that people have about Burlington and the crime problem. Many people are not going to Burlington anymore. Many people that I know who would go to Burlington for dinner simply aren't going there because they don't feel safe. And it's not that necessarily what this person says is true. It's the perception that is true. And the perception is one that people get charged with crimes in Vermont and are released on conditions, and they violate those conditions. And they're released on conditions again, and they violate those conditions. And we all know that we don't want to put people in jail simply because they can't afford bail. And there have to be some things that we can do that perhaps gives the public confidence, that also keeps people who are habitual criminals. The person who's gotten 4 felony convictions, has 4 felony charges, has 15 misdemeanor charges, has 110 in one cases, contacts with the police within the last year, and that person is still out on conditions of release and continuing to violate those conditions of release. And it seems as though we're impotent to do much about it. This bill is designed to at least deal with the issue of bail and conditions of release, and it may not be perfect. It may be a starting point for a committee of jurisdiction to look at. If this isn't the answer, what is the answer? But I think people are asking us to do something about this and to try to come up with the best answer we can. That's it in a nutshell, Mr. Chair.
We have, I think, 3 or 4 bills that deal with bail issues. Some of them are larger than others. This is the biggest one.
Well, the simplest thing is I was thinking about
We're
this.
going to bring out one omnibus bill out of the 4, but I appreciate, what you're trying to do here. There is a perception problem, but there's also a very real problem, particularly in that group that you outlined, who continually violate conditions of release and continually that is ignored. Except in the case where the Department of Corrections has somebody on home detention, there is no supervision of individuals by any state agency or the courts while they're out on conditions. Also, another problem is somebody is incarcerated for the weekend, let's say. They are caught on Friday night, they get incarcerated, they get out on Monday morning when there's an arraignment, and there's nothing. there may be conditions set, but there's nobody there to say, you're gonna we're gonna do a screening of you, we're gonna do this, we're gonna do that, you know. So, you're outlining some serious problems, and we're looking at how to best deal with them. I appreciate it. Are there any questions for Senator Brock?
I don't have a question, just a statement. I believe that when Senator Brock received that letter, the timing of it or whatever else, where blank still was out and about. But in defense of the Vermont State Police, I believe he now has been picked up and is incarcerated, being held without bail, and his female accomplice has been released. I don't know if it's with bail or not bail, but they have reacted to this as to the timing of it. I don't know, but he has now been incarcerated, so.
Yeah, that's great. I should have mentioned that. Thank you.
The other thing that we're trying to deal with, and I don't know what bill it'll be on, is the eviction of people who are come into a community, set up shop in somebody's apartment, who nobody leased to those people. And usually it's a trade of drugs for the use of the apartment. So how can we evict those people immediately out of that apartment? We've had a number of cases with problems with that, so that's another area that we're certainly looking at.
Well, I realize your committee has a great challenge to deal with these issues. They're important issues, and I appreciate you taking the time to do it.
Thank you. By the way, Lieutenant Daniels and I found the state police to be very responsive. We let them know this problem.
Yeah, absolutely. And the comment is the comment of the constituent. This is what they said. It's not necessarily what actually is happening.
Okay, Ben, do you want to give us the highlights? Yes.
I just have a quick comment, and I do think it's really important that we recognize that perception and reality can be really different, and that we ground policy in reality.
Well, yeah, it only takes one person with 45 charges,
Yes,
new charges.
but I don't want to harm 300 people because one person is driving a
I agree.
perception.
I don't disagree with that, but on the other hand, I think we have to do a better job. If we're gonna leave people in the community, we have to do a better job of supervising them and making sure that they are behaving in a manner that's acceptable.
Could not agree with you more.
That's the problem in my mind.
Yeah, because I do think sometimes when we highlight and really talk about the perception as if it is fact, we sort of drive that perception. I've been to Burlington a lot and I've never felt unsafe.
Well, I don't go to,
It's kind of far away for you.
well, we can't get there without going out of state.
You wouldn't want to do that.
No, I don't want to go out of state. Ben, welcome.
Senator Sears, thank
Well,
you.
you've been here all morning. So.
Yeah, just a observer. That's my watch. Okay.
Just give us the 18-minute version.
Sure. For the record, my name is Ben Obrogoski from the Office of Legislative Counsel. Before I get into the bill, just a couple things to remember throughout the whole bail conversation is I recommend just using this as sort of a quick reference guide from a couple weeks ago. And a couple things to highlight, just given the testimony that we've heard today, is that Vermont does have different constitutional restrictions than the federal government does when it comes to bail. In Vermont, as opposed to the federal government, everybody is bailable as of right with those limited exceptions. The sole constitutionally legitimate purpose of bail is to secure someone's appearance in court. And then as far as bail revocation and that state v. Sov or Swab case that Attorney Jones was referring to. So repeated violations of conditions of release in a manner that impedes the prosecution of the accused is a basis to revoke bail. However, the courts have said that violations alone are insufficient and there must be a nexus between the repeated violations and a disruption of the prosecution. So there is a little bit of a difference in language between what the statute requires and then what the law, the case law has said is that there's a difference between, well, what's impeding the prosecution and what's a disruption of
That's where
prosecution.
the problem comes in, is the term, in my opinion, term repeated, and are you saying that's a constitutionally protected?
Well, not so much
Because
repeated, but the difference between, I mean, disruption, which is what the court has said, disruption of the prosecution, or impediment of the prosecution was what the statute says. And some people have argued that an impediment to prosecution might be broader than a disruption of prosecution.
If I were an attorney and my client has violated the conditions of release by committing a new crime or allegedly committed a new crime, are you saying that that alone wouldn't be enough?
Can you say the question one more time, Senator Sears?
Individual violates the conditions of release by allegedly committing a new crime and is charged with that new crime. Are you saying that violation wouldn't be enough to revoke the bail or hold without bail, whatever?
It probably would be insufficient. Disruption of the prosecution typically.
But can we change that law, or is that constitutionally protected?
That would be a constitutional issue.
Revocation of bail, as we last heard it, was, if in fact, I know what you're shooting for, Senator Sears. Under VCR, if someone commits another crime, we should look at repealing their bail or taking their bail from them. But the way this is written now, I believe it states that it has to be a similar crime from the one that was committed, or a crime against a person
Repeated.
and then the revocation bail may come in.
Well, the term repeated is in.
Yeah, and it's not so much repeatedly being the constitutional issue, it's what constitutes an impediment to prosecution. So it could be something along the lines of, if someone's violating conditions of release, for instance, let's say they can't have contact with a certain person, and that person's going to be a witness in the case. If they repeatedly violate their condition and not have that contact with them to essentially scare them from testifying, that could be something that's considered an impediment to prosecution.
But I'm still. Yeah, anyway, go ahead. I mean, this has to do with 287, because I think 287. Anyway, go ahead. Specifically, the bill proposed to lift the 200 cap on bail for persons who committed new offense.
Yes, there are several provisions.
That's what brings up that question.
Right. So yes, to get into the details of the bill is entitled An Act Relating to Bail and Violations of Conditions of Release. It proposes to do a variety of things, one of which, as Mr. Chair, as you alluded to, is that it does propose to lift the $200 cap on bail for persons who commit a new offense while on pretrial release. It explicitly permits a court to consider whether a person subject to pretrial release or community supervision, and whether they are compliant with current court orders when setting those conditions of release. It also creates an expedited summary procedure for violations of conditions of release. It prohibits repeat offenders from being referred to diversion. It permits courts to consider any violations of conditions of release for sentencing, and it requires a report of the Attorney General and DOC annually on various data related to diversion referrals and other programs employing restorative justice principles or programs. And then also adds the carrying of a firearm to drug crimes as one that could be considered a violent crime. So I'll get into the details of the bill, but that's the broad
Similar to
overview.
what's in S-158 for juveniles.
Potentially, I'm not familiar.
Well, it would make it a big 12 offense to have a firearm while committing a felony.
Okay.
For juveniles.
Okay. So getting into the details of the bill itself, you'll see in section 1, it amends 13 VSA 7551. which is about how bail is imposed regards secured appearance bonds and appearance bonds generally. You'll see that on line 15, it strikes subsection B, subdivision 1, so that no bail may be imposed at the initial appearance of a person charged with a misdemeanor if the person was cited for the offense in accordance with Rule 3 of the Vermont Rules of Criminal Procedure. So basically what this would do is that this is eliminating that cap, because right now you'll see what's struck is in subdivision B, at the initial appearance or upon the temporary release pursuant to Rule 5B, a person charged with a violation of a misdemeanor offense that is eligible for expungement pursuant to, so right at the outset, it gets rid of that requirement. But it also adds that in subdivision 2, that the $200 limit. So right now, the way it works is that someone who is considered a risk of flight for an expungable misdemeanor, they can have bail imposed on them, but no greater than $200. What this would do is now limit the $200 cap so that it would not apply to an offense committed by a defendant who's been released pending trial for another offense, even if that offense was an expungable misdemeanor. Yes, sir. Yes.
So it's a second.
Yes, if they're out on release and they commit another crime that would be subject to that $200 cap, that's lifted for that second.
Okay.
Regardless of what that crime is or how it's related to the initial crime. So it's not a repetitive sort of the same type of crime. It's
Correct.
just any, including possibly if the choice was made to charge the crime of violating conditions of release, that wouldn't be a crime for anyone else. It is for me now, my bail.
Well, so as a violation of conditions of release?
Like, would that be, the state's attorney charged that as a crime? Would that apply here, theoretically?
It could be.
Thanks.
Okay, go ahead.
So that's the portion that affects 7551. If you go to section 2, which amends 13 VSA 7554, outside of some just grammatical, gender neutral language updates, you'll see that on page 4, line 16, and also on line 10, there were some updates just to keep the definition of risk of flight from prosecution consistent throughout. I'll go over that when we get to it later in the bill. But on line 16, it now adds place of abode as one of the restrictions that the court can impose on a defendant in their conditions of release. Right now, it's only limited to the restrictions on travel or who they associate with. Now it would be restrictions on the person's place of abode during the period of release. Again, on page 5, just updating sort of those gender neutral terms and making sure the definition is consistent throughout. There are no changes on page 6. Page 7 has some substantial changes in subdivision 2. So right now, in subdivision A2, so if you recall from my prior presentation on bail and conditions of release, there's the initial bail analysis in 7554. There's also then sort of the public safety analysis. This is getting into that secondary analysis here. So in subdivision A2, the judicial officer, on the basis of available information, shall take into account the nature and circumstances of the offense charged, the weight of the evidence against the accused's family ties, employment, character, mental condition, length of residence, record of convictions, record of appearance, or a flight from prosecution or failure to appear. It now also adds things so that the court can consider is whether the accused is subject to release on personal recognizance or subject to conditions of release prior to trial, sentencing, or appeal in another case pending before federal or state court. So basically, if they're subject to some sort of condition, or if they're out on their own, either pre-trial or pre-sentencing, that's something else that can be considered by the court. whether the accused is on probation, parole, or furlough, or some other form of community supervision in another case that's already been adjudicated. So a separate case, and they're on some sort of conditions as part of their probation, parole, or furlough. That's something else that can be considered. And then finally, if the accused is currently compliant with any standing court orders. So if they're already subject to conditions of release and they violated them, or if they're compliant, that's something that could be considered in imposing new conditions with a nexus to protect public protection.
Quick question for you, Ben, is this very last sentence, whether they're compliant with any standing court orders, is that, how similar is that to what we saw in 195? I might be.
Well, in 195, I believe it's if some of the language is if they have to take into account the recency of any pending charges, and then also the number of offenses with which they're charged. So it is different.
Yeah. Okay.
And it wouldn't necessarily be restricted to just an order of conditions. It would be any standing court order. So it would be broader than that.
Okay, thanks.
Go on to section 3.
On to section 3. So section 3 is essentially the accountability mechanism for violations of conditions of release. It creates a new statute, section 7554E. And what this does is that it creates a mechanism basically to arrest somebody and create a summary procedure to hold them to account very quickly if they violated conditions of release. So there are a few ways that this can happen. On subsection A1, when a person's alleged to have violated a condition of release ordered by the court pursuant to the bail statute, the person may be arrested or cited to appear before the court in which the conditions of release were ordered. So they can be arrested or come to court, but it has to be the same court that issued the initial orders. 2, a judicial officer may issue a warrant for the arrest of the person charged with violating the conditions of release, and they must appear. And then 3, the person alleged to have violated a condition of release shall appear before the judge not later than the next business day following the arrest or citation for a summary hearing. This is similar to that flash citation that you heard Attorney Jones speak to a little while ago. Subsection B outlines the hearing procedures and the rules of evidence and the burden shifting that occurs in this summary procedure. So 1, a person appearing before the court pursuant to this section shall be entitled to a hearing to determine whether their condition of release was violated. In making that determination, the judge or judicial officer shall consider various factors. 1, whether probable cause exists that the person committed an offense under federal or state law while subject to conditions, or whether clear and convincing evidence shows that the person violated a condition, and finds that there's no condition or combination of conditions that would reasonably ensure the person's court appearance, mitigate the person's risk of flight, or reasonably protect the public, or the person's unlikely to abide by any condition or combination of condition of release. 2, the judicial officer shall issue an appropriate order addressing the alleged violation. And that's dictated by subsection D, which I'll get into. Subsection C talks about the burden of proof, admissible evidence, and rebuttable presumptions. The state has a clear and convincing standard to prove the violation. So that's not as high as beyond a reasonable doubt, but higher than preponderance of the evidence. So it has to be more than 50%, but not quite to a certainty. It has to essentially be reliable. 2, this is the admissibility standard, so our rules of evidence standard. Information stated in or offered in connection with any order entered pursuant to this section need not conform to the rules pertaining to the admissibility of evidence in a court of law. This is the same language that the committee has seen in S-196, so the rules of evidence would not apply to this hearing. 3, if probable cause is found by the court while subject to conditions of release that the person committed an offense under federal or state law, a rebuttable presumption arises that no condition or combination of conditions of release will reasonably protect that, ensure that person's court appearance, mitigate the risk of flight, or protect the public. So that's something that can be rebutted by the defendant. But if probable cause is found by the judge, that then creates the presumption that there aren't any conditions that can mitigate the risk of flight or protect the public. On 4, in cases subject to D4, and you'll see D4, this is for those cases where life imprisonment is a potential sentence or those violent crimes. So we're talking about those 3 exceptions to the presumption of bail for people in this state, that when a person violates a condition of release or commits a new criminal offense, a presumption also arises in that instance that no condition or combination of conditions will reasonably ensure their appearance, mitigate the risk of flight, or reasonably protect the public when a person violates that condition or commits a new criminal offense. So now in subsection D, we get into the disposition of violations. So what does the court do once it's found that a violation has occurred? So if the judicial officer finds that a condition or a combination of conditions of release, or that there is a combination of conditions of release that will reasonably ensure the court appearances or mitigate risk of flight or protect the public, they shall essentially use 7554 and 7551, the ones that already dictate bail, to amend the current conditions of release accordingly. So it could essentially impose more restrictions on the individual. Under subdivision 2, if there are no conditions that would reasonably ensure their appearance in court, mitigate the risk of flight or public protection, or that the person's unlikely to abide by such conditions, the judicial officer may commit the person to the custody of the Department of Correction or Commissioner of Corrections as a detainee, subject to the limitations later outlined in the subsection, provided that the court determines that such commitment is reasonably necessary to assist in the management of the conduct or behavior of the person. So if that is determined, there are certain graduated sanctions, if you will, to hold the person. One, that for a first violation, someone can be held for not more than 14 days. For a second violation of a condition of release, they can be held for not more than 30 days. On page 14, this continues that for a third violation or any new criminal offense under federal or state law that the person commits while under conditions, they cannot serve more than 30 days for that third violation or that new crime. And then fourth, not for any amount of time, but at a minimum 30 days, if the judicial officer determines that it's necessary to assist in the management or behavior of the person for a fourth or subsequent violation of a condition of release, or that the person has committed a new crime. So those are the graduated sanctions.
Senator Bahowski has a question, and then we're gonna stop right here.
Yeah,
I don't think we should go to section 4.
so in the language around committing a new crime, is that charged with or having gone through the process and convicted of?
Not convicted.
So it's not it's alleged to have committed a new crime?
Yes.
Okay. Is this constitutional?
Well, so that's why there would have to be that probable cause determination.
But under our constitution, we can only hold someone if it's a public safety.
So the part that I think needs to be flagged for the committee is that when we're talking about bail, we're only, the sole constitutionally legitimate purpose of bail is to ensure someone's appearance in court.
Right.
However, bail, the conditions associated with bail, if they are considered to be insufficient to protect the public, additional conditions can be imposed. So that's the framework with which we're working under in the state. What this does is that it adds public protection as one of those considerations. It ties it to appearance of court in court and mitigating the risk of flight. So it kind of conflates it all. There may be a constitutional issue with that, but And that's why, part of the reason what I wanted to flag for the committee is that, I know this is going farther into the bill centers here, so my apologies.
Yep.
But in 75, 76, I'm trying to find the page for a quick reference, is the definition of risk of flight from prosecution. What this does is that it adds non-compliance with court orders. Here we go. It's on the top of page 17. So 75, 76. Flight from prosecution means any action or behavior undertaken by a person charged with a criminal offense to avoid court proceedings, including non-compliance with court orders and failures to appear at court hearings. Flight from prosecution, again, that's tied to bail. There can be court orders that are related to public safety, or ones that are not. So this could be overly inclusive when it comes to that definition of flight from prosecution. So really, but again, that's something that reasonable minds may differ on, but just knowing where our constitutional structure and case law is with bail, and that the sole constitutional purpose of it is to prevent or mitigate the risk of flight from prosecution, adding to that definition non-compliance of court orders could create a situation where it's not tied to securing someone's appearance at court, because it might be a condition that you don't have contact with somebody.
But
But we're getting, but it's all related. It's
Yeah.
complicated, but it's all related to that question.
that you gave us earlier seems to indicate that you can do more than risk of flight, that community safety is
The way it does is that if the conditions related to bail are insufficient
Yeah.
to protect the public, additional restrictions can be imposed. But there is this concept that bail itself is really only there to secure appearance. So if we're adding to the definition of flight from prosecution, which is directly tied to bail, situations that may take it beyond that, that's an issue that I think the committee should be aware of.
Well, my question was sort of on the other end of that
Well,
spectrum of
yeah.
holding people pre-trial. Like, my understanding under the Constitution is that can only be done if certain criteria are met around public safety. And so now we're saying, oh, you violated a condition of release. It's mandatory that before you've been charged with that, you're going to be held for it's that freedom aspect.
So it is a balance. I mean, they are given a hearing, they are, there's notice and a hearing, and so there is that process. It's done in a summary fashion. And it's this balance of public protection versus individual liberty. I can't tell you where the
Okay.
Supreme Court would fall
Fair.
on this particular issue.
Well, we're gonna end with that admission by Ben that he doesn't know.
I don't expect him to have a